Senior Living series. We're really happy you guys are here. If you don't know already, the Inspired Living series, we feature new topics and guest speakers on the first Thursday of every month at 10 a.m. So the entire team includes Andre Boyd and Sierra Dubé, Nicole Noner, Kimberly Shute, and me, Peter Wilhelm. Today, our topic is key legal documents for planning for the future. We're going to have a question and answer period at the end of the session, but if a question comes to you during the presentation, feel free to write it in the chat box and we'll make sure it gets addressed. So without much further ado, I want to introduce our guest speaker for today, the wonderful Michael Rose. Michael is an elder law attorney based in Lake Oswego. His practice is focused on assisting clients through the retirement years with thoughtful estate plans and crisis management. He earned his Juris Doctor degree from Willamette University College of Law and his undergraduate degree from Brigham Young University. Michael comes from a long line of Oregonians who helped settle the mid-Willamette Valley, and he's a husband and father of 3. Welcome, Michael.
Thank you, Peter. Appreciate it. So yeah, real quick, just because we are in doing Zoom, I'm at home and you may hear a 2-year-old screaming in the background. And it's possible you could hear older children yelling and screaming in the background, and possibly even my wife screaming at them. So anyway, it's a fun time. We're just enjoying it for what it is. And I hope that you'll enjoy the message today. I'm going to go ahead and share my screen with you, and that is my family. Let me get the slides going if I can. There we go. All right. So we are going to be discussing advanced planning today, key legal documents that you'll need in order to make sure that you are protected, your family is protected, and your estate is protected in case something happens to you. And we'll call this part 1. Okay, there's not nearly enough time to get through all of the information that I'd love to share with you today. But we'll go through some of the what I think are really important issues today. We're going to be focusing on what happens if you don't die. Okay, so again, a lot of us, I repeat this joke probably too often, but a lot of us plan to wake up dead one day. Most of us are not planning on what happens if I don't die, but I have a stroke, or I get dementia, or I have an accident and become incapacitated. There's just so many different ways that we can lose our cognitive function, and it's really important that we plan for that. The likelihood of ending up in long-term care is increasing as the doctors find ways to keep us alive longer. Long life can be a great thing if we're not experiencing these physical problems. And I heard a joke one time by an older person that said, I found that there is a lot of lead in the years that are called golden. So we need to plan for what happens if we don't die. So first of all, I just want to mention what is an elder law attorney. So I'm an elder law attorney. What does that mean to me? That means that I'm an estate planning attorney. I help people plan for death as well as these long-term care issues. So we do lots of power of attorney, advanced directive, wills and trusts, all those sorts of things. But there's a difference between an elder law attorney and a traditional estate planning attorney, and that is that traditional estate planning attorneys, you will find, mostly are helping people to plan for death. They're really focused on, how do we pass the estate on? How can we protect it from estate taxes and those sorts of big important issues? Elder law attorneys do recognize that there's a lot of life before death. And so we're hypersensitive to what happens if we lose capacity. A big issue with losing capacity is long-term care. We may need to go into an assisted living or memory care or adult foster home or a nursing home. There's so many different types of places we may end up being, and what can we do to protect ourselves, protect our families, protect our estate if we end up in that type of situation. So that's what elder law attorneys do. So just to get things rolling here, we asked the question, why plan? Why do we do all of this? Well, Benjamin Franklin said it best: if you fail to plan, you plan to fail. Not planning is a plan, it's just a really bad one, right? Poorly thought out. And again, this is where a lot of people fit in, where they just think, oh, one day I'll pass away and that'll be the end, right? Well, not exactly. We need to plan for what happens if we lose capacity. That's a really key component to our plan. So what happens if you do lose capacity and you don't have a plan in place? Well, first of all, let me say a lot of people that are married are under the impression that if I lose capacity or my spouse loses capacity, we'll be able to manage each other's financial affairs because we're married. Now, that is totally untrue. And it needs to be really understood that just because you're married does not give you any authority over your spouse's finances or other assets or medical care. We have to be given authority to manage those things for our spouse. So a lot of people, and I've done this presentation so many times, over and over, and a lot of people are under this impression, oh, my spouse can manage it. A lot of people think, oh, my adult child can take care of it, or whatever. But the reality is you don't have a plan in place. What are we left with? Our only solution is to hire an attorney to petition a court and seek to have a guardian and or a conservator appointed for us to make those decisions. So quick story about me. When I got married early on in our marriage, my wife and I moved, and I hastily set up the utilities. And not thinking much about it, a few months later, my wife called me one day and she said, hey, you forgot to pay the electric bill. So I called to pay the bill and they won't even talk to me. And she said, I explained I was your wife, but they said, we don't care. If you're not the person on the account, then we're not going to talk to you. They wouldn't even take her money. And so she was kind of frustrated by that. And of course, I knew better. I just wasn't thinking very clearly when I set up the utilities. I did not put my wife's name on the account. This is the world that we live in. We have all different types of accounts, whether it's a liability or an asset. And if your name is not associated with that account, you have zero access to that account. This is going to include things like email, your Facebook account, all types of social media accounts, but everything that you can think of, if it has your name on it, if your name is associated with it, you're the one that has those ownership rights, and everybody else is excluded. I'm going to share a few more tragic stories in a few minutes of why this is so important, but that's, my personal story. So we learn these lessons the hard way sometimes. Okay, so if you don't have a plan in place, there are two other really important things that I think should be mentioned, and that is that if you don't have a plan in place and you lose capacity, you may lose important benefits that you're otherwise entitled to. And your spouse may lose their estate trying to pay for your care. That's a really big deal. So what is a guardianship and a conservatorship? The guardianship is a court supervised proceeding in which a judge appoints another person, your guardian, to manage your personal affairs. That means that they are going to be the one to choose where you live, what type of food you're going to eat, who you get to associate with. We've had a lot of guardians make it impossible for their other family members to come and see them. But they get to choose what type of medical care you're going to receive, right? What types of medications you're going to receive, what kind of treatment plans you're going to be on. They have what we call, in legal terms, plenary authority, which means all power to make decisions for you and your life. So that's the court guardian. The court conservator is also a supervised proceeding in which a conservator is appointed to manage your finances or your assets. If you have more than $10,000 in assets and you lose capacity, a court will appoint a conservator to manage those assets for you. So just because you have a guardian doesn't mean you'll have a conservator, but you can also have a conservator and not a guardian. I don't have time to get into those differences too much, but just know that what's really important about this is a few things. First of all, the cost. It is incredibly expensive to have a guardian and conservator appointed to manage your personal affairs. At a minimum, it's probably going to cost around $4,000 to get the guardian and conservator appointed. That's going to be court costs because there's fees associated with filing and attorney's fees. And then for the rest of your life, it's going to cost $1,000 to file annual reports. And some important things to keep in mind about that is you are the one that pays for that, right? So if I lose capacity and somebody needs to be appointed as my guardian, I have to pay those attorney's fees. I have to pay for all of the fees that are associated with taking care of me, just like I'm going to be paying all my own doctor's bills and everything else. It's expensive. And if for whatever reason, a judge determines that I need an attorney to represent me against the person who's filing the petition in court, wanting to get a guardian for me, the costs are going to skyrocket. We had a woman last year that was in the hospital that needed to be placed, but she couldn't go to a memory care because she didn't have anybody nominated as a power of attorney. She didn't have an advanced directive in place. So we couldn't move her unless we had a guardian appointed for her. And when we petitioned the court to appoint a guardian, the judge said, hey, she would benefit from having an attorney represent her. At the end of the day, after objections were filed and hearings were held, it cost us, just on our side, about $12,000 to get the guardian in place. And the other attorney's fees were around $3,000 as well. So guess who got to pay? Mom got to pay both attorney's fees. And that's really sad. It's so expensive. So if we can avoid that, that's the, that should be our goal. The other reasons why we don't like guardianships and conservatorships is that they are public proceedings. These happen in the public sphere. I can literally go onto the court e-file and look at all of the new guardianships that are being filed and tell you who's lost capacity, what happened in their life that has brought about this petition for guardianship. It's really embarrassing. It's intrusive. We get to see what all of your assets are. We get to find out who your family members are. All kinds of information in those court records. And last but not least is that when a judge determines that you are in fact incapacitated, that judge is going to strip you of your constitutional and God-given rights to make your own decisions. Right now, I can choose to live on the street. If I want to go live downtown under a bridge with the other half of Portland, I can do that. That's my right. And but at some point, if I've lost capacity and they can prove that I've lost capacity and I need protection from myself, a judge will say, I'm sorry, you no longer have the right to decide those things for yourself. So we're going to appoint a guardian to do that for you. Okay, so how do we avoid the guardianship and the conservatorship? Well, the two main documents that I want to focus on today are power of attorney for healthcare and the power of attorney for finances and the advanced directive for healthcare. These are the two most important documents that you can have in place today. It's very easy to get these documents set up. So first of all, let's talk about the durable power of attorney for finances. What is this document? How does it work? There are a lot of misconceptions about the power of attorney. It's so important to understand what this document is and why it does what it does, because the misunderstandings actually lead to a lot of problems. So first of all, what is the power of attorney document? It's actually an employment contract. We're saying that, look, for instance, when I give power of attorney to my wife, what we're saying is I, Michael Rose, as an employer, am hiring my wife, Holly, as my employee. Okay? So what am I hiring her to do? Well, that's why the document must be in writing. The document must explicitly spell out which activities my agent is able to perform. Am I frozen? Can anybody hear me? Can you guys hear me? Okay, good. Something popped up on the computer screen and said, you're unstable. All right, so before I became an attorney, I had my own business. I was painting houses in San Diego for several years, and it was a fun time. I worked in some of the biggest housing communities in San Diego, multi-million-dollar homes, and had a blast. But my business grew so much that I had to hire employees to come in and take care of all the things that I couldn't do. There's so much prep involved with painting, and all of the painting itself is a lot of work. So the same thing is true with this power of attorney document. What your document says and doesn't say is going to be so important with regard to the type of help your agent can give to you. Okay, so I want to give some specific examples of this. For instance, I have a lot of clients that come into the office and say, my mom gave me power of attorney and I took it to the bank and they won't honor it. And so we look at the power of attorney document and it's completely silent on the issue of banking, right? It doesn't say anything about the agent being able to go to the bank and withdraw money. That may seem crazy to you, but the reality is people are downloading power of attorney documents from the internet thinking that they can just get a one-size-fits-all document. They download it, they sign it, and then somebody takes it to the bank a year later or 2 years later or whatever, and they find out that that document is not even worth the paper that it's written on. Okay, that happens all the time. So that's kind of a specific example of what happens if you don't have something in the document. Another example is what happens if you have something in the document that can cause problems. Is there a potential for that? And there is. Let me skip to this slide here and just get down to the bottom to talk about that. There's this, at the bottom there it says, what about springing powers? What is the springing power? Well, in your document, you can literally say, this document is not effective until my agent can prove that I'm incapacitated. And usually what that says is 2 doctors must declare that I'm incapacitated. A lot of people want this in their document. It gives them a warm, fuzzy feeling inside to think, oh, this document, I mean, it literally is the key to your financial kingdom, right? You're giving somebody else authority to invade your bank accounts, take all your money out, sell your home, do all of these things. And they think, oh, well, I wouldn't want them to have that authority until I'm incapacitated. First of all, what's the problem with that thinking? The problem is that if you cannot trust your agent while you have capacity, what makes you think you could trust them when you don't have capacity? Now, some people might argue, well, if I don't have capacity, then I won't care what happens to my assets. Yeah, maybe, but you still want to be taken care of. And certainly you don't want your agent stealing all of your assets while, there are other family members that you intended to provide for. So it's really important that we not trust this springing power. Not only because you're putting too much trust in it, and thinking, well, at least they won't be able to do anything wrong while I've got capacity. Hey, while you've got capacity, you can look at your bank statements each month and know if somebody's taking money out. You can also see them pounding the for sale sign into the ground in your front yard, right? I mean, these things are pretty obvious, and you'll be able to know if somebody's taking advantage of you. When you don't have capacity, you won't. So the first thing is to be very, very cautious about who you nominate as your agent under power of attorney. This is by far the most common form of elder abuse, when somebody gives their adult child or somebody else authority to pay bills and take care of them if they're no longer able to do it on their own, because they can take that document, turn around, and wipe out your bank accounts. And most of the time, it could be an honest error too. We had a young man who was taking care of his grandma. She gave him power of attorney, and he used it to use grandma's money to buy new tires for his monster truck, right? He had one of these big jacked up trucks, and he bought tires for it, and the tires were like $2,000. And he told us, well, grandma would want me to do that because I'm running all over town trying to take care of her. Yeah, well, we might agree with that on some level, but if it's not in the document, it doesn't specifically say, hey, my grandson can buy himself new tires for his truck, then that's a potential elder abuse claim. We have to be so careful what we do when we're helping out somebody that we love under the power of attorney. So going back to this springing power, the springing power is also, it can also be very problematic for a couple of reasons. One of the biggest reasons is that two doctors have to declare you to be incapacitated. I had a young lady come to my office, say, Mom is on the dementia roller coaster, right? She's kind of up and down. And sometimes I think she's really getting what we're talking about. And other times it's like, wow, she's really far gone. And she had a serious problem because she wasn't paying any of her bills, and she was giving all her money away on the phone and the internet to strangers. And daughter was just like, oh my gosh, we've got to do something. We've got to save mom from herself. So she dug around in mom's files and found mom's estate plan. She pulled out this beautifully drafted power of attorney. She started reading it and found this clause that said that this document is not effective until two doctors declare me to be incapacitated. So daughter takes mom to the doctor, and the doctor quizzes mom. And guess what? Mom's riding high on the dementia roller coaster, and she's answering all the questions, right? And doctor turns to the daughter and says, yeah, mom's got dementia. We know that, but she's okay. And I'm not going to sign that letter. Why? Because the doctors don't want to get sued. So daughter took mom to 3 different doctors, and none of them would sign a letter. So she was stuck. Here mom is giving all her money away, not paying any of her bills, and daughter's completely helpless. What did we have to do? We had to file a petition with the court and ask a judge to appoint her to be mom's conservator. That was really tragic. Mom went to an attorney in Lake Oswego, spent good money on getting an estate plan in place, and that estate plan turned out to be totally worthless, right? So we had to spend thousands upon thousands of dollars more to protect mom from herself because she had dementia and the document had this springing power in it. So be very, very careful who you nominate as your agent. Be very, very careful what type of language is in the document and what type of language is not in the document. There are things that should be in there. There are things that should not be in there. One of the big issues that we come across all the time as elder law attorneys are people who are going into long-term care. we get this call at least once and sometimes twice a week where somebody says, hey, dad's going into long-term care and mom's going to stay at home. And we need to try to protect the assets for mom so that she doesn't lose her house. And we want to help dad qualify for Medicaid. We say, okay, does dad have capacity? Generally, the answer is no. Dad is so far gone. They've waited and waited and waited. Dad is so far gone. Now he's got to go into care. And so dad doesn't have capacity. So the next question we ask is, who has power of attorney for dad? Oftentimes the answer is nobody, but a lot of the time we'll get a power of attorney document. Our first question is what does that power of attorney document allow us to do? Remember, the document must explicitly state what authority the agent is being given. So we want to know, what can the agent do on dad's behalf? So when it comes to qualifying for government benefits, whether it's Medicaid or some other type of benefit, we want to help them to preserve assets. This can be a really important factor for a lot of our families, especially married couples. How do we preserve those assets? Well, the law allows us to do a number of different things to try to preserve assets. But at the end of the day, dad has to be the one to do those activities, or he must have given specific authority in his power of attorney document to allow his agent to do them on his behalf. Number one might be preserving assets for his spouse. We have to have authority that says my agent can transfer my assets to my spouse, especially if the spouse is the agent under power of attorney, because even though they're married, it's a conflict of interest for his wife to take his assets. This law clearly says, hey, if you're acting as agent, right, you're an employee. If you're stealing the assets of your employer, that's wrong, right? And so there has to be something in your document that says my agent can distribute my assets to themselves if they're my spouse, and I waive any conflict of interest. So there are a number of other things that we could get into. I don't have time for that, but I just want to make very, very clear that what your document says or doesn't say can make a huge difference. In fact, it could literally save you hundreds of thousands of dollars. And that's what it comes down to for a lot of our clients. The clients that did not spend a few $100s to get the right power of attorney in place could cost them tens of thousands, if not hundreds of thousands of dollars. And that can be a real tragedy. So what I always tell people is, look, there are literally billions of different kinds of power of attorney documents out there. You can make up your own power of attorney. You don't have to do anything special. You just write down on a piece of paper, I'm giving my agent the authority to do X. People in real estate see this all the time. You'll give your agent, your real estate agent, authority to do something, or you'll give, I don't know, a title company authority to do something. And those are limited power of attorneys, right? Those documents are very limited in scope. They just say, hey, my agent may do X on my behalf. And that will generally end on a certain date. Here, you're giving a broad range of activities to your agent with no expiration date. And so you've got to be very careful what kind of activities you're allowing your agents to do. So I tell people, look, there are power of attorney documents, and then there are power of attorney documents, right? So your power of attorney could be like a bookstore document or an online document that are probably going to provide for a lot of the things that most of us think we need. You know, paying the bills, writing checks on our behalf, taking money out of our bank account, managing utilities, selling our house, some of those really basic things. And for some people, that may be all you need. And so I tell people all the time, look, if you're not married, you don't have any kids, and you really don't have any assets, at minimum, spend $10 at the bookstore and get a power of attorney document. But if you have something that's worth protecting, if you've got a house, you've got a spouse, you've got children, whatever it is, if you have something that's worth protecting, it's worth getting a document that will fit your needs. So I compare them to the pocket knife. When I was a Boy Scout, I always carried around the Boy Scout knife. It was a one-bladed knife, and it did everything I wanted it to, because all I was interested in was whittling and sometimes stabbing the heck out of a tree or something like that, right? But when I became a contractor, I actually started carrying around a Leatherman. These Leathermen are just ideal for so many different things. I literally used it several times an hour when I was a contractor. You've got the pliers, you've got the knife, you've got the little scissors, you've got the screwdrivers, all kinds of things. What you want is a power of attorney that has everything that you could possibly need to take care of you, your family, and your estate in the event that you lose capacity. Okay. Just because the power or the document says it's a power of attorney, it doesn't mean anything, right? It could literally say my agent is allowed to go to the bank and pay bills. Or it could be something much more substantial. So when people come to our office and talk about power of attorney, and they find out that our documents at a minimum are 11 pages long and will go up to 30 pages, they kind of go, wow, we start talking about what the importance is of all these different clauses. It really starts to sink in for them. But it's a little bit crazy to think that there's just literally, probably millions of people in this country that have gone to the bookstore and got the one page, one big block paragraph power of attorney that is probably not going to do what they need it to do. Power of attorney is one of your most important documents. Okay, so I only have a few more minutes left. I want to talk about Advanced Directive. This also is one of your most important legal documents. Super important. Everybody should have this. And this one, as opposed to your power of attorney for finances, this one is a one-size-fits-all document. And the best part is it's free. Hey, you can get it literally from online or at the doctor's office, and you can get it from my website. You can go to my website and download it for free. There's almost no excuse for not having an advanced directive in place. Now, one excuse most people have is it's confusing. I agree. The advanced directive document has historically been very, very confusing. In 2019, the legislature updated the document and made it much more user-friendly, easier to understand, easier to fill out, and gave us some additional options that I'll talk about. But everybody should have this document. What is it? So the Advanced Directive is two different documents that the state of Oregon back in the early 90s thought, hey, these documents are really handy. We really like them. Let's smash them together and we'll call it the Advanced Directive. And Oregon was the pioneer, okay? Oregon, to my knowledge, was the first state to do this. And since then, all other states have followed suit. So what did they do? They took the durable power of attorney for healthcare, not finances, not legal issues, healthcare, a durable power of attorney for healthcare, and a living will, and they smashed it together, and they called it the Advanced Directive. So what are these two documents? The durable power of attorney for healthcare is, just like it sounds, allows another person, your agent or your employee, to be able to talk to the doctors and make healthcare related decisions for you. They're the person that's going to approve medication and treatment options and where you're going to live and those sorts of things. The living will, there's a lot of confusion about the living will. This, if you'll get this term straight, you're going to be leaps and bounds ahead of most people. When most people say living will, they're either thinking of a will or their trust, but they're not thinking of the Advanced Directive. A living will is where you get to express your wishes with regard to life support and tube feeding. So the document asks you, hey, if you're in one of these 4 situations, would you want life support or tube feeding? First one is if you're close to death. What about permanently unconscious or advanced progressive illness or an extraordinary suffering? If you're in one of those 4 situations, we know you're going to die. Your death is imminent, but we can prolong your life if we hook you up to the machines and put a tube down your throat to feed you food, right? So those are very, very drastic circumstances that you're going to be in. Not everybody is going to fit into these circumstances, but those are the 4 circumstances that you're given: close to death, permanently unconscious, advanced progressive illness, or an extraordinary suffering. Do you want life support or tube feeding if you're in one of those 4? And the answers that you can give are yes, I do, no, I don't, or only as my physician recommends. The beautiful thing about this living will is the opportunity for you to let us know what your wishes are. It's an opportunity for you to say, wow, if something happened and I cannot communicate with the world, and the only way for me to continue to live is to be connected to the machines, you can say whether or not you want us to do that. Early on in my practice, when I started helping people with this sort of thing, I had a really terrible situation. A young family came in. Their daughter was a student at Willamette University, and she was about 21, and she tried to commit suicide. She was in the ICU, and the family was just absolutely, horrified that this happened. And they were, number one, they had to decide, whether to keep her on life support and tube feeding. She was basically brain dead, but there were still possibilities that she could come out of it, right? There's a huge, huge long shot that she would ever come out of this. And so the family struggled for weeks with whether or not to pull the plug. And, if she would have had an advanced directive in place and said, hey, if I'm in this type of situation, just let me go, that might have been really helpful for the family and given them a little bit more peace to know that they made the right decision. The other part is going back to the power of attorney. They wanted answers. They wanted to know why she would want to commit suicide. She had her whole life ahead of her. She was a brilliant young lady. She had friends. They could, for the life of them, figure out why she would want to do this. And so they started thinking, well, maybe it's on her Facebook or Instagram or other social media. They started calling around to get the information. And of course, Facebook wouldn't let her into her account. Twitter wouldn't let the parents in. All of these different places, every single time they'd say, hey, we're her parents. They'd say, we don't care. You're not her. You don't have access. You don't have any right to access those accounts. Electronic accounts are such a big deal these days, right? We're all using it. Even my 93-year-old grandmother is on Facebook. She uses Zoom with us. She does all sorts of things online. You have to have a power of attorney that allows your agent to be able to use or to get into your Facebook account or even just your email or online banking. And so that family had to make a decision, either file for a guardianship or wait till she passed away and open up a probate to get the information that they were looking for. But that was a really tragic situation, and it didn't go very well for them, unfortunately. I wish it did. But I just want to say that, the advanced directive is so important. It's so easy to fill out. There's a couple of questions that came up with the advanced directive. Number one was about additional wishes. You can write out all your wishes as much as you want. You can add addendums to the advanced directive. And I always recommend that you do. If you have things that are specific to you, let the world know. How would you want to be taken care of? Honestly, most people are totally lost and they have no idea what to add. If you get the Advanced Directive booklet from the hospital, it will come with a number of different pages that will ask you all kinds of great questions that you can answer. If you get the Advanced Directive from our office as part of an estate plan, we'll also include a worksheet for you to fill out. It's going to ask you all kinds of questions, like 8 pages long, that will help you to think about what kinds of things might be an issue if you lose capacity. So the Advanced Directive is a fantastic document. The other part is, how do we sign this document? Well, in 2019, the legislature changed the document to allow for a notary. So you can either have your signature notarized, or you can have 2 witnesses sign your document. So if you sign in front of 2 witnesses, those witnesses cannot be your treating physician, and they cannot be those persons that you've nominated as your healthcare representative. But you can have anybody else sign the document and say, hey, we saw this person sign this document. And that's a really nice change. The last one is, when we're talking about the Advanced Directive, people always ask, oh, is this the POLST? Is this the pink sheet that you're talking about? And of course, the answer is no. The POLST is completely different, is totally different, although they are related. And yes, you probably need both. The POLST is, again, in 2019, there was a slight change made to the POLST form. Part of it was in the title. It used to be called a physician's order for life-sustaining treatment, and now it's called a portable order for life-sustaining treatment. And what is the point of this document? Well, remember, the Advanced Directive is what happens if I'm alive but incapacitated and somebody needs to take care of me. The POLST is, hey, what happens if you die? What happens if your heart stops beating, you stop breathing, and we want to know, do you want us to try to save your life? Do you want us to try to resuscitate you? And so a lot of people call the POLST a DNR, a do not resuscitate form. Yes, it's the pink form that you'll see when you go to some people's homes. It's on the refrigerator. It might be next to their bed. I've seen people post it to the front of their door, because what happens is if you collapse, we call 911, the EMT will arrive and they want to know, do you want us to try to save your life? If you don't say anything, if you don't have this document on hand, then the EMT are going to do their best to try to save your life. And you're going to get some brawny 20 or 30 something year old pumping on your chest. And unfortunately, it's a brutal process. They will break your ribs. It will puncture your lungs. They will bruise you from head to toe to try to save your life. And many times it is effective. They are able to save people's lives this way. But I've had clients who are well into their 80s who have been resuscitated, and they really regretted it. They said, I wish I would have had a POLST in place, because the recovery from being resuscitated was horrible. I had one lady that had been resuscitated a year before, and she said, I'm still recovering. And she said, I don't know if I'll ever fully recover, because it was just so hard on my body. So the POLST is a super important document if you're of the opinion that you don't want to be resuscitated. And even if you do want to be resuscitated, you can say, hey, resuscitate me. They have other options on that form. What you really need to know about the POLST, though, is you cannot get it from an attorney. I can't do this document for you. You have to get it from your doctor. Okay, the doctor has to sign this document. So, okay, that's it. I know we're out of time. I'll just leave this last slide up. If you want a free 30-minute consultation, feel free to call Amber at the office and she will give you a free 30-minute consult.
Great. Thank you so much, Michael. That was really, really informative. We do have quite a few questions.
Okay.
So I'm going to scroll up to the top. One of the first ones we had was, who has to prove loss of capacity? You talked about to doctors, but what are some examples of proof?
It depends on the context. So what I was talking about there was a springing power of attorney. And the springing power of attorney will tell you what is required. So most springing power of attorney documents will say, um, two doctors must declare that I'm incapacitated, right? So they have to write a letter that says Michael Rose has lost his marbles and can no longer function and take care of his own legal and financial issues. And then we get two doctors to say the same thing. When it comes to guardianship and conservatorship, the judge is the one who's going to make that decision. And it could be circumstantial evidence, or it could be direct evidence from a doctor stating the circumstances. There can be all kinds of different evidence to come forward in a guardianship proceeding. So it doesn't have to be specifically doctor's notes, although doctor's notes for us are really kind of the shoe-in for a guardianship. Whenever we take on a guardianship client or a client to help get a guardian in place, we want to know, hey, are we doing the right thing? Do we have enough evidence to suggest that this person actually needs a guardian? So it really depends on the circumstances of why we're trying to prove incapacity.
Gotcha. And then the next one was, why would a guardian not honor the preferences of an incapacitated person?
Why would a guardian not honor the preferences? It would likely be because they don't know what those preferences are. And at the end of the day, so when it comes to guardianship, when it comes to guardian, power of attorney, advanced directive, that what we're doing is called substitute decision making. We're putting another person in our place, saying we trust this person to make the best decisions for us. But at the end of the day, they're the one making the decision, and they're the one that has to weigh all of the options. And if they don't know what your preferences are, then they're not going to be able to make the decision that you want. But when it comes to, this may be a more specific question. Somebody's probably out there going, well, I know so-and-so that did this, and I know what they would have wanted and they didn't do it. But I don't know what those circumstances are. I don't know why somebody wouldn't do something that I'll just tell you, when my dad died, he died in 2007. He was the catalyst for me to leave the world of painting and become a lawyer. And he wanted to be cremated. I kind of knew that in the back of my mind, but instead I found a nice coffin and we buried him. And I had some family members that were really upset with me at that time. And to be honest, it was so spur of the moment. He died so young. I was so overwhelmed with all the choices, and my family was too. I felt like nobody was helping me, and they just put it all on my shoulders, and I had to make a decision. And I just kind of felt like, we would all like to be able to see him before he goes. And there were so many things going on in my head at that time. It was a hard decision to make, but it is what it is. People will get over it sometimes. Yeah. I don't know if that answers the question very well, but.
Thank you. If Medicaid might be needed for long-term care, when should someone begin planning for that?
Yesterday.
Okay, good. And when would you recommend having a POLST?
When, this is really a good question for a doctor. I think we have a nurse with us, don't we? When is a good time to get a POLST in place?
I would say the same thing, yesterday.
Yeah. So I've heard several doctors say it really depends on your circumstances. Sierra, I don't know if that's what you think too. I mean, if you're my age, should I have a POLST in place?
Yeah, I think it totally depends on your circumstances. But I do think, going back to what you were saying of, things happen unexpectedly, and to young people that don't expect it, or to family members that don't expect it to happen to their children, like, it's always helpful to know what they're wanting or what they're not wanting, so that you can follow their wishes instead of having, regrets later on that you didn't do what they were wanting you to do.
It's just that extra layer, right, of protection for what you want to have happen. I mean, if you're young and you become, you come in and you're quote, dead, do you want to be resuscitated? Like, it's the same for a young person as it is for an old person. So it's, to me, it's another layer of protection.
Good.
Do you need to show capacity to make decisions in order to make changes to a will, POA, things like that?
Absolutely. Yeah. Yeah. I can't work with you if you don't have capacity. And that's going to be a personal judgment call for me. Every attorney has to make that call. But if you call me up and say, hey, my dad's, experiencing dementia, that's going to be one strike against you, right? The first thing is that I can't set an appointment for your dad with you calling in. He has to be the one to call me to set the appointment himself. He has to know why he's making that appointment. And I'm going to quiz him. I'm going to ask him all kinds of questions, whether it's a superficial question or something that's personal. I'm going to ask him all kinds of questions to find out his level of capacity. Now, just because somebody's on the dementia roller coaster doesn't mean they can't sign legal documents. People can have lucid moments. And as long as they're lucid in the moment when they're in there, and I know that they get it, that this is what they want, and I'm willing to take the witness stand on their behalf, then I will have them sign documents, right? Because at the end of the day, what we're concerned about is somebody complaining that these documents are invalid. Invalid because they didn't have capacity. And I'm putting my reputation and my money on the line because somebody's going to sue me for malpractice by having somebody sign those documents. So if I'm willing to take the witness stand, we know we're good. But yes, they should absolutely show that they've got legal capacity to sign those documents.
Great. What happens if you become incapacitated in another state? Do the same documents you have filed in your state cross lines?
Sure. Yeah, they do. And, you've got to be careful because, for instance, if you're moving to another state, I recommend you update your documents. But, when you're in the United States, generally speaking, every state is going to honor the documents that you've signed in Oregon. I think it's probably generally true if you go to a different country as well, to some extent. But again, if you're going to move somewhere permanently, update your documents.
If a child is out of state and the mom is showing signs of not taking care of her financial and health needs, who would she contact for guardianship?
The child is, so we've got an adult child that lives out of state, and we've got mom that lives in Oregon, or mom lives somewhere else.
I think mom lives, yeah, correct. Mom lives in Oregon.
Okay, so if mom lives in Oregon, then you'd contact an Oregon attorney to discuss getting a guardianship in place. Yeah, if mom's in California, you're going to contact a California attorney.
Okay. And then what about social media? Regarding social media, is it enough to simply leave passwords in a document, or did you need to give explicit permissions for an agent to access those accounts?
You absolutely have to give explicit permission. Otherwise, somebody's illegally accessing your account. Even though my wife has my access, my login and passwords and everything, and I've orally given her that permission. If something were to happen and somebody were to cry foul, if she doesn't show the power of attorney that I have for her, that says that she can access those things, she could get in trouble. And I know we all do this to some extent, some level. I even help my clients sometimes when they say, hey, I want you to log into my account to help me with beneficiaries or whatever. And generally speaking, they're right there with me and whatnot. But yeah, we have to be really careful, and you definitely should have a power of attorney document that explicitly states my agent can access these electronic accounts.
Great. And how often should things like wills, POA, all the advanced directives be reviewed?
You know, as I always say, your documents are static, but your life isn't, right? Your life is going to continually move and change. People are going to come into your life. People are going to go out of your life. Divorces happen, deaths happen, you know, and this is, you know, not just for yourself, but your family. So I think that you should update or look at your documents at least every year on your own. Talk to your attorney at least every 5 years. My clients, I will, when they do an estate plan with us, I'll invite them every 3 years to do a free 30-minute review just to make sure everything still matches. Some people take advantage of that, some people don't, but at least you've got the option. Hey guys, it's been 3 years, you know, if anything has changed, let us know. Or if you just want to sit down and discuss what's going on in your family, we're happy to do that for 30 minutes. I know that's not very typical for attorneys, but we want to make sure that our client's plan is going to continue to meet their needs throughout their life.
Great. Probably just one more question. Does the POA have to agree to being the POA?
They don't have to agree, but it's a really good idea. Right? Because the reality is we've had clients who've nominated people, and when it came down to it, the person said, I don't want to do it. You know, it is a lot of work. And, you know, a few years ago, my mom called me up and said, hey, I'm updating my power of attorney. I want to make you my agent. And I said, Mom, I love you, but I don't want to do it. You know, I'm glad you asked, because let's think about it. You know, I've got a family, I've got my business, I'm super busy, and I know what it means to be a power of attorney. It means work. And I honestly don't need that added burden. And I said, you know, ask my sister. She doesn't have as much going on. She is brilliant with money and she is really close to you. So I have her as the first and I'll be the second. If she can't do it, then I'll step in. You know, and that, I thought that was a better fit for me personally. But yeah, you should probably ask them if they are willing to do that.
Excellent.
Michael, thank you very much. We greatly appreciate your insight, your expertise on these important issues, and most importantly, your time as well. And wonderful questions, everybody. Super informative session. A couple of quick things before we go. So please watch your email for some follow-up information. We'll be sure to share Michael's contact info again, and then also a quick survey. And then also just a plug for next month, we're going to meet again at 10 a.m. on the first Thursday. That's May 6th. And we're going to be following up this legal documents talk with a key financial documents talk. So should be great. Thanks again. Hope you have a wonderful day.
Thanks, you guys.
Thank you.
Oh, hold on. Sorry. I think there is one last question. Do we have time, Michael?
I'm fine. Go ahead.
Okay, sorry. If someone is an executor of an estate, does that work as a durable power of attorney, or do they
Good.
differ?
This is a great question. No, it does not. They're two separate things. So when you're an agent under durable power of attorney, that is a very specific role. When you are an executor under a will, again, a very specific role. I've had a lot of people come into my office and say, Mom's incapacitated, but I am her executor under her will. And we have to say, sorry, that means nothing, because the will is not effective until somebody passes away, right?
Great. Thank you so much. Sorry for the late.
Oh, it's fine. Yeah.
Thank you. That was
Thanks,
so
everyone.
great.
Yeah.
That was just fabulous.
Yeah. Thanks for having me, everybody.
Yeah. Thank you so much, Michael.
Thanks.
Have a good day, everyone.